Today I'm going to focus on the probable cause affidavit that was used to procure an arrest warrant for Dana Chandler back in 2011. By way of background, the tragic murders of Michael Cisco and Karen Hartness occurred on July 7th, 2002, when they were shot multiple times while asleep in their bed in Topeka, Kansas. Dana Chandler at the time lived 540 miles away, and during the preliminary hearing, Dana Chandler's lawyer, Mark Bennett, specifically asked the lead detective, Sergeant Richard Volle, whether he was ever able to find anybody who informed him that Dana Chandler was in Kansas or in Shawnee County or in Topeka the weekend of July 5th, 6th, or 7th. And his answer was just simply one word: no. So if Dana Chandler were on trial for being in Kansas the weekend of the murders, she could not be found guilty. That is the honest truth about this prosecution. They have zero evidence that Dana Chandler was even in the state of Kansas. And that's from Richard Volle's own admission. And yet Jacqie Spradling created this entire fabrication that after Dana was in Topeka, Kansas and murdered 2 people, according to her, then she went straight north to Nebraska, where she filled up with gas and headed back to Colorado. And that whole theory has been completely debunked. And during the disciplinary hearing, Deputy District Attorney Charles Kitt and Richard Volle admitted that there was no evidence that Dana Chandler was ever in Nebraska, that those were just theories. Now, how many of you would want to be convicted based on someone's theories, or their hypotheticals, or their possibilities, or their guesses, or speculations, or conjectures? That should never be enough to convict someone of a crime as serious as murder, one that carries a penalty of life behind bars. And yet that's what happened. So they couldn't even establish that she was in Kansas, but then they put her in Nebraska, all based on a theory. Now, this is incredulous. Getting back to the probable cause affidavit, probable cause affidavit begins with the words, "I, Richard Volle, of lawful age and being duly sworn, depose and state the following." The first paragraph states, based on investigation by the affiant and other law enforcement officers, the affiant believes that there is probable cause to believe that Dana Chandler murdered Karen Hartness and Michael Cisco on July 7th, 2002, between 1:30 and 3:45 while they were asleep in their bed in Topeka, Kansas. Now, you would assume, since this was written by Richard Volle and begins with "I, Richard Volle," that it would also be signed by Richard Volle, but it was not. It was actually signed under penalty of perjury by someone by the name of former Lieutenant Kipp Low, K-I-P-P, last name L-O-W, from the Topeka Police Department. The final paragraph of the probable cause affidavit, showing that Richard Volle did not sign the affidavit, Lieutenant Kipp Low signed it under penalty of perjury, and it states as follows: all investigative leads have been concluded with the volume of the evidence indicating that Chandler could not accept the news that her ex-husband was newly engaged to be married. Based on her inability to accept the relationship was over, the fact that she was being replaced by another woman, and the stalking behavior evidencing this control Chandler wanted to maintain over Cisco, your affiant believes Chandler murdered both Cisco and Hartness. Further affiant saith not. Wherefore the undersigned requests that a warrant be issued for the arrest of Dana Chandler. I verify under penalty of perjury that the foregoing is true and correct. but it's not signed by Richard Volle, the affiant. It's signed by, again, Lieutenant Kipp Low. And it's notarized by a notary public. Now, this is very problematic, and yet this fatal defect in the entire case against Dana Chandler has been completely ignored by law enforcement. My husband filed a complaint against Richard Volle and Lieutenant Kipp Low with Kansas Sea Post, which certifies law enforcement officials in Kansas, and he did not even receive a written response to his formal complaints. He received a phone call from someone from Kansas Sea Post stating that they were not going to pursue the matter further. And that was the extent of the investigation. Well, there wasn't an investigation. They chose not to investigate. Richard Volle was asked about that by Jacqie Spradling's attorney, L.J. Leatherman, during her disciplinary hearing, and he asked whether a complaint had been filed against him. And Sergeant Volle said yes, and was it by key number? Yes. And were you exonerated from that complaint? And Sergeant Volle stated, either as far as I know or to the best of my recollection. But what they told us was they weren't going to pursue it. So if he received even a slap on the wrist, we don't know about it. But the point is, this deserves more than a slap on the wrist. This is in violation of the Fourth Amendment of the Constitution. Chief Judge Richard Anderson, he's now Chief Judge, at the time he was Judge Richard Anderson, actually accepted this warrant, either didn't notice that it wasn't signed by the affiant. I'm going to assume that, because I don't think he would have granted the warrant for Dana Chandler's arrest based on a faulty affidavit. This is a defective probable cause affidavit, and yet it kicked off the entire case against Dana Chandler. So I'm going to read the relevant part of the Fourth Amendment to the United States Constitution, and it reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation." So the problem with this affidavit is a warrant was issued for Dana Chandler's arrest with a probable cause affidavit that was not supported by oath or affirmation. In fact, it contains evidence of perjury. Lieutenant Kipp Low signed this under penalty of perjury. Has he received any penalty? No. And we've tried to alert law enforcement officials to this fact. When my husband filed the complaint against Jacqie Spradling 4 years ago, one of the counts was pertaining to this faulty affidavit. This is a defective affidavit. This is a fatal flaw in the arrest of Dana Chandler for the murders of Michael Cisco and Karen Harkness. Richard Volle can't be held responsible for the content of the probable cause affidavit because he didn't sign it. Do we hold Kipp Low responsible? He didn't write it. This probable cause affidavit is no more valid than a will that is written by one person saying that, being of sound mind, they are, describing what they are going to bequeath to various individuals, and then signed by somebody other than the person who wrote the will. I mean, this is the dirty little secret about the Dana Chandler prosecution, is that the very document used to obtain the search warrant the very document used to obtain the arrest warrant for Dana Chandler has a fatal flaw. It's not signed by the affiant. But speaking of search warrants, my faux pas, this same probable cause affidavit was used when they went to Oklahoma to arrest Dana and to convince a judge down there that he should also issue a warrant for her arrest in Oklahoma. And according to Richard Volle's testimony, couple weeks ago during Jacqie Spradling's disciplinary hearing. He stated that it was used for various search warrants. So all kinds of illegal activities resulted from a defective probable cause affidavit that was not signed by Richard Volle. In addition, I'd like to point out that the fact that the affidavit was not signed by Richard Volle was recognized by Judge Nancy Parrish during Dana Chandler's trial. So I'm going to read from a transcript of the trial, March 12th, 2012. I believe that would have been about day 4 of the trial. Judge Parrish recognized the defect in the affidavit of probable cause and stated the following. This says, it looks like Kipp Low's, Judge Parrish stated. Jacqie Spradling. Kipp Low signed the affidavit for Sergeant Volle, who was out of town at the time the case was filed. Judge Parrish. I'm not going to, it says Richard Volle, and I wouldn't anyway, just as a, it looks like someone other than Detective Volle signed this. I'm not sure how the affidavit is any good when someone other than the person who is the affiant signs it. So I have grave concerns about admitting for those reasons, and in addition to the reasons Mr. Bennett mentioned. So Judge Parrish stated that she had grave concerns about this probable cause affidavit because it wasn't signed by the affiant. There are many people involved in this case who are aware that Judge Richard Anderson signed a warrant for Dana's arrest in violation of the 4th Amendment to the Constitution, which says, again, no warrants shall issue, but upon probable cause supported by oath or affirmation. A probable cause affidavit that's not signed is not supported by oath or affirmation. Richard Volle is the author of the document, but he is not the signer. And that makes it an invalid document. So Dana Chandler's very arrest was a violation of her 4th Amendment right not to be arrested without probable cause supported by oath or affirmation. In addition, I'd like to point out something in the probable cause affidavit itself. In the affidavit, there is an interesting paragraph where Richard Volle states, he's discussing the May 2003 search warrant that was executed for Dana's person, where she was transported to Stormont Vale. And it states that they took hairs so that they could compare it to the scene. And he then writes, in parentheses, we may want to remove or add to this section, the hairs did not match Chandler's DNA. So when asked about that during Jacqie Spradling's hearing, Richard Volle feigned ignorance or could not remember writing that, didn't know if he wrote that, but it's in there. It's in the affidavit, the faulty affidavit signed by Kipp Low. We may want to remove or add to this section because the hairs did not match Chandler. None of the fingerprints, and there were many slides of fingerprints that were submitted for testing, none of those matched Dana Chandler. None of the hairs collected or the vacuum sweepings that they collected from Karen's bedroom where the murders took place, none of those matched Dana Chandler. And the hair that was found attached to the shell casing, which FBI forensic scientist Dr. John Stewart testified that he tested, and he was able to eliminate both victims and Dana Chandler as the source of that hair. And this was not given to Dana's attorney until a few days before the trial began. So why that particular hair wasn't tested until just 2 months before the trial began is another mystery. But in any event, it did not match Dana Chandler's. And this was identified as a limb hair, meaning either arm or leg hair. And it was melded to one of the shell casings. And the weapon was identified as a 9mm carbine rifle, which is an Uzi style weapon. But we'll address that some other time. In any event, the affidavit used to get search warrants, to get Dana's arrest warrant, and to try her for murder was faulty and defective. And so, as long as Dana Chandler is still in prison, I think it's important that some of these discrepancies be revealed, because I'm hoping there's somebody out there that does care, because Kansas Seapost didn't care when we alerted them to the fact that a sergeant with the Topeka Police Department, Sergeant Richard Volle, prepared an affidavit in a double homicide after the case went cold for 9 years. He was the lead detective in it, but yet he failed to sign his own probable cause affidavit. And that faulty document, which was signed by somebody unrelated to the investigation, Lieutenant Kipp Low, this was used to violate Dana Chandler's Fourth Amendment right not to be arrested without probable cause supported by oath or affirmation, not to have her Denver apartment searched while she was attending the funeral of her ex-husband, not to have her home, her cell records, her computers, her financial records all violated, tax returns, all based on a defective probable cause affidavit. I don't know how this happened. I don't know why it happened, but it happened. And I call upon Chief Judge Richard Anderson to prepare his own affidavit, to acknowledge his own mistake, oversight, in signing a warrant for Dana Chandler's arrest without the requisite probable cause affidavit supported by oath or affirmation.